Good morning. We are doing this session, I think, after a month now, kind of took a break and restarting again. But before we start the session, I would like to acknowledge that Legal Aid BC head office is situated on the unceded territories of the Coast Salish peoples, including the territories of the Musqueam, Squamish, and Tsleil-Waututh nations. I would also like to acknowledge that many of you are joining us today from many places near and far and acknowledge the traditional owners and caretakers of those lands. Thank you for joining the session today. Welcome again. As we are starting the session today, along with me is Sarah Chow and Alessia Mordini. Special thanks to Alessia for creating such a wonderful introduction slides. I hope all the participants got a chance to listen to them or have a look at them. And Sarah Chow, I always say that they both are the backbone of these sessions. Without them, it's very hard for us to run these sessions. Some tips for the session to share. Our speaker is open to ask questions during the session. So please feel free to ask questions. You can either type the questions in Q&A or you can unmute yourself and ask the questions directly from her. There will also, we always encourage to get your feedback. I always say that your feedback helps us to mold our training, mold our sessions, and there is a prize associated with the survey which Alessia will post towards the end of the session. Please fill out that survey, send it to us, and we will send your prize to you via email. With this note, it's my pleasure to introduce our beautiful and wonderful speaker who always is helpful and ready to present whenever we ask her, Kamaljit Lehal from Lehal Law Group. Kamaljit Lehal earned her law degree from the University of British Columbia in 1989 and was called to the British Columbia Bar in 1990. Kamaljit opened up her own law firm in 1992 and operates a successful practice with the focus on immigration, personal injury, WCB, and mediation. Kamaljit's clients who have been prosecuted and are seeking refugee status in Canada, she's always passionate to help them. She's also passionate to help the representation of women on gender prosecution grounds. She's assisted families in reuniting with their loved ones in Canada. Her representation of immigration clients has been at all levels, including the Federal Court of Appeal. Kamaljit is connected to her heritage and enjoys participating in cultural community events. She is an alumni of the Indo-Canadian Women's Association, a nonprofit organization aimed at empowering and educating South Asian community. She's also helpful to the youth and always working on bringing self-esteem and other wonderful skills, helping them. She's fluent in Punjabi and speaks Hindi. Please join me to welcome Kamaljit Lehal in today's session. Thank you, Kamaljit, for joining us today.
Thank you. Good morning, everyone. Thank you, Baljinder, for that introduction. I'll have to send you an updated bio. I'm actually only practicing immigration now. I've got rid of the other practices as immigration and mediation, devoting after 32 years, just focused on this area now. But thank you for the introduction. I'm speaking from North Delta, which is on the shared and traditional ancestral unceded territories of the Tawasan, Musqueam, and Coast Salish peoples. I'm really excited to be here. I'm always excited when Baljinder asks me to come and speak to people in the community about topics that I am passionate about. So today I'm going to be speaking about vulnerable populations and some of the legal remedies available to them. Next slide. So the two categories that I will be speaking to is women fleeing violence and foreign workers who are being abused. Next slide. And you'll note here, there's about 45 slides. There's a lot of slides, and I don't want to be that talking head, talking at people. So if you have questions as I'm going through the slides and sharing information, please feel free to ask me. I'll also pause between the two topics. So after I finish talking about the family violence, victims of family violence, I'll pause there to see if there's any further questions on that topic before we move into foreign workers. So I think we all know, I got some feedback from Baljinder and her lovely crew as to who was going to be attending today. So we have, my understanding is settlement workers, multicultural outreach workers, local immigrant service coordinators, various people from community services. So you will all be familiar with the fact that women who are fleeing violence have to navigate a number of hurdles in order to get to safety. It's not a straight trajectory out of leaving an abusive situation to getting to safety. They may be also involved in the criminal justice system if charges have been laid, in the family court system, as well as there may be MCFD involved if there's children involved. So they're navigating a pretty complex path out of an abusive relationship to safety. Next slide. But when it's an immigrant woman, when we add the layer of the woman who's being abused and make her an immigrant woman, the situation becomes even more complex because we're dealing with matters of her status, and she's dealing with then the immigration system, which tends to operate in its own silo. And when in my area of work that I do for immigrant women, the women that I'm most involved with in helping are immigrant women who have either no status or precarious status. We'll go to the next slide. So what do I mean by out of status or precarious status? So the scenarios I see are women who've come into the country with some kind of status. It may have been a visitor status. They end up in a relationship with a Canadian or permanent resident, and for some reason think because they're in a relationship that they don't need to renew their status, they fall out of status, or they remain in that status, in that visitor status, but I call it precarious because it's hinged on their relationship with that partner or spouse that they have in Canada. And the typical profile is that the woman may or may not have children, and that there may be removals or threats of removals. So there may be an actual removal order if she's fallen out of status. And what you have to understand is that if there's a removal order under the Immigration Act that we have, or by Immigration and Refugee Protection Act, the CBSA, the Canada Border Services Agency, are actually mandated by law to remove people as soon as possible. That's what the law requires them to do. So this individual may be under an actual removal order, or there may be a threat of removal, and that's not uncommon. I was involved in a project in 2009. It was a 3-year project with EVA BC, Mosaic, and the Family Multicultural Society, where we did focus groups across BC, and a common theme that emerged was that women were told by their spouse or partner that if they reported the abuse, that they could be removed from Canada, that the partner would have them deported from Canada. So there's really a disincentive for women to leave the abusive relationship if there's threats of removal. So next slide. This one talks a bit further about sort of the control by partners and spouses of a immigrant woman. And I'm just going to pause there and say, I refer to the victim as a woman because the people that come before me are women, and statistics show time and time again, it is a woman that is more likely and at high risk for interpersonal violence as well as homicide. And I think we saw during the pandemic, we saw an epidemic within the pandemic. I know in BC, there was up to a 300% hike in domestic violence reports. So when I speak, you'll hear me say woman, referring to the victim as a woman. It's because that's who walks into my office for help. That's who the statistics time and time again indicate are at highest risk. So again, and what this slide is speaking to is that a common control tactic by the Canadian spouse is that to control the actual paperwork, the ability for the person to get status. So typically, if you're in a genuine relationship, your Canadian citizen spouse or permanent resident spouse would apply for your landing through a spousal application. But what we see in these power control abusive relationships is that the Canadian partner controls whether they're even going to submit that paperwork, or they say it's been submitted and it's not been submitted, or they threaten to withdraw the application. And what you have to be mindful of is that, in fact, the application can be withdrawn at any time before a decision has been made. And I'll just share an example of a case that I recently reviewed in federal court, which was an appeal from a refused humanitarian application. And the victim, a woman, was experiencing just that. Her spouse had put in a spousal application, then withdrew it. Then he put it in again, and she actually received approval in principle. She actually got a work permit. And then just before she would have gotten her PR, he withdrew the application. So a lot of power in the hands of an abusive party over an immigrant woman who's experiencing violence. I'm just looking at the chat here. It says, can you please confirm that threats of removal are not valid? I'm wondering if a woman who is married would potentially lose her immigration status if her spouse divorced. Okay, I'm trying to understand. Well, if a person is under a removal order, then that's a removal order that is enforceable. If someone is out of status and has no status, then threats of them being removed, there's a real chance they could be, or that removals process could be started. I'm not quite sure about the rest of the question. Maybe we'll deal with it a little bit later. And maybe when I go through the rest of the slides, some of the remedies that I speak to will help answer that. So next slide. So how do we help victims of violence navigate through the systems? Like I've said, they're already maybe going through a number of systems and processes, and they're dealing with the immigration system now. What are some of the remedies available to them? And really, it's if they're out of status, it's something called a TRP, or temporary resident permit. And if they want to secure permanent resident status in Canada, it would be a humanitarian and compassionate application. Next slide. So these processes have been available for a long time, the TRP and the HNC. They've been available for, I would say, decades. The concern with what I'm calling the standard process, because there is now an expedited process, with the standard process was that it took a long time. So TRPs would take 6 months plus onwards to process. And an HNC application, again, an HNC would secure permanent resident status, could take 2 years plus to process. And during that time, there was very limited supports or resources available to the victim. And again, concerns of removals was always there. So, sorry, I've got a little bit of a tickle in my throat here. So again, not much incentive to women to leave an abusive relationship if what they're leaving is and going to is very uncertain, and there's a high risk of them being removed, and there's no supports. Next slide. So
you want to answer?
Sorry?
There is a question here you want to answer?
Oh, what's the question?
It's do you have any advice for immigrants who need to get their PR card replaced but don't have any connections to people who have known them long enough to sign a declaration or any valid ID to support the application. Everything is expired, lost.
Oh, gosh, I haven't had that scenario, but I would probably be getting an affidavit from the victim themselves explaining what has happened and piecing together their ID somehow by way of, like, even if there's a copy of a birth certificate or someone can send it from abroad, piecing that together and doing an affidavit. So yeah, that would be a tough situation if everything is lost or if everything is taken away. Maybe some kind of freedom of information request of their immigration file could reveal some of those documents. Okay, so I'm going to jump back to the topic here, which is what I wanted to, I just spoke about how the remedies available to victims of family violence was and always has been this TRP and H&C, but the problems with it was that they just took so long and there was not enough support or benefits resources, and there was real risk of victims being removed. So for about a decade, stakeholders had discussions with policy people from immigration, asking them to apply a trauma-informed approach to dealing with victims of violence who are out of status or who have precarious status. The focus really was on those that were out of status. My apologies. So in July of 2019, after, like I said, a decade of these discussions, an expedited process was announced for victims of family violence. And this was an expedited process for both the TRP and the H&C. And how they were expedited is that there's this coding that was established, FV for family violence. That coding is placed on the front of the TRP application, the front of the H&C application, to flag it for priority processing. And what I can say in terms of processing time, and I think I'll get into it a bit later as well, but the TRP, if you are calling into the call center, it's supposed to take them 2 days to respond back. If you're actually sending the application, it doesn't specify the timeline, but from my understanding, from speaking with policy people, it's supposed to be around a 4 to 5 week turnaround time. And for the expedited H&C, I can speak from experience that I had, and again, I'll go into it, I'm jumping the gun here a bit, but I had one of my clients recently receive first stage approval in a month, and 3 months after that, she was landed. So a big difference from the traditional length of time it was taking. And so I put a link in here so you can get more information and details about this expedited process. But next slide. Some of the key features about this, and I'm speaking to the TRP first. I'll speak to the H&C after. I want to cover the TRP application first. Again, that's a temporary resident permit that takes a person from out of status, giving them some temporary status. So, and that will prevent the removals process from happening. So there's no fee for the initial expedited TRP for victims of family violence. You can apply simultaneously as when you're applying for the TRP, you can apply for a fee-exempt open work permit as well. And then you can apply for interim federal health coverage. So these concerns that we saw were dissuading victims from leaving abusive relationships before, they're being addressed here. Some of the concerns, again, they didn't have resources, ability to get on their feet. So there's an open work permit now, which allows them to start working and get on with supporting themselves if they're in the mindset to do so. And I'm going to speak to what I mean by that a little bit later, because not every victim is able to leave an abusive circumstance and start working right away. But that option is definitely available. And the bottom bullet there, which I think is, to me, the most important in terms of peace of mind for the victim, is that in the policy directives on the expedited TRP, the Canada Border Services Agency is instructed to consult with immigration, IRCC, before taking any removals action. So that fear that women had, that if they came out of the abusive relationship without status and being removed, that has been addressed. So I was really happy to see that instruction there, that they're not going to be removed while the application is being processed. And obviously, if they got TRP status, they wouldn't be removed. Next slide. This is a bit of legalese, but what I want you to take away from here is when TRP applications are assessed by an officer, typically what an officer is looking at is to be eligible for this, to apply for a TRP, typically you have to be either inadmissible or you don't meet the provisions of the Immigration Act. So out of status people are obviously, they are inadmissible, they're in breach of their stay here, they're without status. So that component remains the same for an officer. Even in this expedited TRP, they're still having to look at individuals that fall in that eligibility bubble. And then their duty, their balancing duty remains the same as well. They're trying to balance Canada's humanitarian objectives with also protecting Canada's health and security. So that doesn't change. So just need you to, I wanted to share with you that there is a legal test when these applications go out, which needs to be met, that, you know, that you're saying that this person is not a health and safety risk to Canadians. There's real humanitarian reasons why this person needs to be granted a TRP. So beyond that, I'm not going to go into it too much, because my understanding would be that if these cases came to you, you would refer them to legal counsel or some agency that does that specific legal work. Next slide. Two of the main requirements, again, I'm still on the TRP, the expedited TRP, is that the foreign national who is a victim is physically in Canada experiencing abuse from a common law partner or spouse. And their ability, the second bullet, to get PR status is contingent on being in a genuine relationship with this person. So those are the two main criteria. And in terms of scenario, we'll go to the next slide, which is packed, but I want to walk you through what scenarios in the spousal context could lead to someone claiming this TRP. So the first one is a foreign national who is an applicant of a spousal application already, and they've left their spouse due to abuse. So an application's out there, they may be out of status though, they've left the relationship, they can apply for an expedited TRP. The second one is that scenario I talked about, that power and control dynamic where the abusive spouse can withdraw an application. It's a scenario where the application's been withdrawn. So those individuals can say, I need a TRP, I'm out of status, I was in this relationship, the application's been withdrawn, and I need to get this TRP. Or the third one is one which is also very common, where the foreign national has been misled and told that the application has been submitted when it hasn't. So those individuals as well would say, you know what, I'm in this predicament, I was told it was submitted, but it hasn't been, and I need a TRP. And the fourth one is someone who was intending to apply through PR, for PR through the genuine relationship, but because of the abuse had to leave. So that whole process hasn't even been started. So these are some of the examples of the scenarios within the spousal context, which can make someone eligible for a TRP. I'm just going to pause here because that's a lot of information. Any questions with respect to what I've just said here?
Not yet. I don't see any questions. Yeah, I think we're good.
Okay,
but
great.
If individuals do have questions, please use the Q&A box and type them in, and Kamaljit will answer them throughout her presentation.
Yeah, and at this point, I would ask that the questions be directed to sort of the information I am imparting. I think we're going to have quite a bit of time at the end here. We do have an hour and a half for other immigration questions that I could could assist with. So the question is, am I dealing with PR and protected persons? My focus is on out of status precarious people, as well persons, as well as foreign workers who are being abused. But if I have time at the end and I can answer questions in that area, I'll definitely try to do so. Next slide. So important, and I've left this sort of like a standalone because I think it's very important. Dependent foreign children of victims of violence are also eligible for the family violence TRP, but they must be in Canada. Next slide. So far, what I'm just seeing, will you present about foreign workers today? Yes. So as I said at the beginning, my first part of my presentation will be on victims of violence, and then I'll have a bit of a pause between that and the next topic, which will be foreign workers. Okay, so up to now I've spoken, we went through the examples of victims of violence in sort of the spousal context and spousal application context. What I wanted to share here, though, is that TRPs could also be granted. Officers have been given the discretion to grant it in other immigration applications, so the non-spousal application, what I call the pure spousal application. So maybe it's a spouse who's applying for permanent resident, and the victim spouse is dependent on that spouse, and her status is somehow fallen out of status. The officer has discretion to issue a TRP in that scenario. I haven't had to use it in that scenario yet, but what I'm again taking from that is outside of the typical spousal application scenarios, if there's other immigration classes where allegations arise, officers have discretion to consider whether a TRP is warranted. And then one other area where they have discretion is if there's a refugee claimant whose claim was not allowed. Typically what happens if your refugee claim has been denied, there's a 1-year bar to apply for a TRP. But the policy framework here for victims of violence is that that bar does not apply to victims of violence. So that's good to know. But those are individuals who've done their refugee claim, found not to be eligible for refugee protection. Those individuals, if they are victims of violence in Canada, would not be subject to that 1-year bar. Next slide.
Hi, Kamaljit. There are a few questions you want to answer now?
Okay, am I missing some? Because I thought I did go down. It was...
They just came in now.
I'm looking here. Mine is... the last thing I see on mine is the chat about the comprehensive overview, which can be found on YouTube.
There's more in the Q&A.
Okay.
And the first one is, what if the abusive spouse does not have PR or citizenship status in Canada? What if the abusive spouse also have precarious status, or they have temporary resident status?
Okay, so the abusive spouse has temporary resident status. I mean, the way that this out of status TRP is designed, it's focused on victims who are out of status in a relationship with a Canadian and a permanent resident. So it's suggesting that they would have to have status. If if the abuser did not have status, I would still try a TRP. It may not be the expedited one, but try for the regular TRP route and say that the victim is out of status, these are the circumstances, and you want to be considered for a TRP. It's an interesting area because I presented, I think, a couple of years ago, and I had someone from the audience say that they had a woman who was on visitor status, actually, apply for the expedited TRP, and it was granted. And policy makes it clear, though, that is only for individuals who are out of status. By law, though, the law says TRPs are for those that are either inadmissible or otherwise don't meet the requirements of the Act. I think by law that you can still request, even if you have visitor status, a TRP. And we've, like I've said, the example I've just given you, the individual did receive a TRP even though they were on visitor status. So if a person were to come to me and they were out of status, their spouse was out of status or had precarious status, I probably would try a dual approach anyways. I probably would try the expedited and then say in the alternative, if they're not eligible under that, then we are asking for the standard TRP.
I think the next question is, do spouse come to Canada directly on PR status? I think this question needs to be more elaborated, but you know better, Kamaljit.
Do spouses come to Canada directly on PR status? I can't see the question, so I'm just hearing what you're saying.
Yeah, can you click on Q&A? You can see the questions.
Yeah, it's just because I've got two screens open. Just a second, I'll see if I can expand this one. Okay, let me have a look.
The question is one line, do spouse come to Canada directly on PR status? I think there's more explanation needed to this question.
Yeah. And the second one, would this TRP applications be covered by legal aid? Yes, they have been covering them. And typically, I don't know what the first question, the spouses come to Canada on PR status. If you're granted approved for PR status, if you've been sponsored by someone, then you're landed once you come to Canada. That's when your PR would start. Okay, so next slide.
Thank you, Kamaljit.
Yeah, this is just, I'm not going to read this. This is just the contact information if someone is a victim and they want to call to find out about applying for a TRP, expedited TRP. And remember, I mentioned earlier that if you're calling in, there's supposed to be like a 2-day turnaround time. If you are applying, then it's supposed to be around a 4 or 5 week turnaround. Although when this whole process started for both the expedited TRP and agency, I found that I got a response on my agency quicker than the TRP, but I think some of the kinks have been sorted out now, and the TRPs are typically being, for victims of family violence, being done in that 4 or 5 week turnaround time. And I encourage people, because I am in contact with the policy people, to, if they're seeing different timelines or if they're longer, just let me know, because I like to share that information with them. Okay, next slide. So just sort of wrapping up the TRP part, I wanted to give some anecdotal feedback. Like I said, I do encourage people to give me feedback. So that's both my colleagues in the legal profession, frontline workers, please reach out to me. And something I heard recently, which was a bit troubling, was these TRPs, the expedited TRPs, are issued for a minimum of 6 months. And again, there's no fee for the initial application. And you can ask for a subsequent TRP, but you would have to pay for that. But what I'm finding, what I've heard from the trenches, like, so to speak, is that subsequent TRPs are being refused because officers are finding that victims are no longer in abusive circumstances. And I find that troubling, because I think if that's sort of the thought process, is really devoid of trauma understanding, and understanding that just because someone leaves the actual physical location of abuse doesn't mean they're not still under trauma and dealing with trauma, or still experiencing abuse, especially if they're engaged in a number of systems, such as a criminal system where they're dealing with the abuser, or the family court system. So there's these ongoing interactions. So I would encourage, and I recently presented at a national conference, and I said, if a decision such as that were to come down, then it should be appealed. one lawyer advised that that did happen to them. And instead of renewing under the expedited TRP, they did the standard TRP and they got it. Which is a shame though, right? Because the expedited TRP is coded, it's flagged, it's meant to be priority processing. It's meant to be based on this trauma-informed understanding. So I was troubled to hear that subsequent renewals were being refused on that basis. And the second point on the anecdotal was what the example that I shared, where I had someone a few years back saying that their victim actually had status, visitor status, and she was able to secure a TRP, expedited TRP. So she wasn't out of status. And I've already shared the third point, that initially I found the agencies were being processed quicker than the TRP. But a bit of good news, there was a recent federal court decision, AB versus Canada, and the citation is there. And this was a case where the victim had applied for both the expedited TRP and the HNC. The TRP was approved, but the HNC was rejected. And it was rejected because the officer said, well, the victim applied for a temporary resident permit, which means she really doesn't want to be here permanently. And that's really illogical because, and totally against what the Immigration Act and regulations are, is that you can have dual processes happen. You can have people in temporary status also applying for permanent resident status. But what I'd like from this decision is some comments of the judge in this decision regarding the expedited TRP piece, and in finding the officer's reasoning to be unreasonable, the court said and described these TRPs as being structured to allow victims time and stability to apply for PR. So I really like that reasoning because it is an understanding of, in my opinion, of trauma, and that victims may need more time. I can give you an example where recently I did an agency application, which my client did have status though, but the agency application took longer than normal. My client was basically off radar for 6 months because she had a really urgent situation arise where her abusive spouse refused to return the children during a parenting time and made false allegations to MCFD, which, you know, took its own time and process. So if she had been out of status or on a TRP, I would have needed to extend that because she was putting out some really, you know, difficult fires there, and her mind wasn't on her status. It was or proceeding with her immigration application. It was on getting her children back. So when we understand that we really have to approach these cases, and all of you have this understanding, but from a trauma lens, when applications are being completed on behalf of people, really detail in there the impact on the victim and what they've been going through to help an officer understand the trauma and the abuse that they've endured. I would be, the question is, does this case now provide much needed precedence? I would be using it if I definitely would be citing it if I needed to seek a renewal. It wasn't a case speaking to renewal, but it was a case that spoke about what the purpose of these expedited TRPs is. And I probably would be citing it in my submissions now anyways, to say that, you know, as stated by the federal court in AB versus Canada, these TRPs are structured to allow victims time to get stability and apply for PR. So yeah, I would use it as a precedent in my own submissions. Next slide. So now we're making a bit of a shift here. We're going into the agency applications. So when I have victims who are out of status and they come to me for legal assistance, I'm simultaneously, as I am getting their TRP application ready, I'm getting their agency application. Remember, the TRP gives temporary status. The agency is the application that can give them permanent resident status. And I just want to have you understand sort of what, when we say H&C, humanitarian compassionate application, what does that mean? These applications are the exception to the rule, the rule being that you will apply under some immigration class or category to come into Canada on PR status. You won't just come into the country and apply for humanitarian grants. So whether it's an economic, whether it's a spousal or application, family class, or some skilled worker class, you're applying through some application or category to secure permanent resident status. If you're not able to meet the requirements of these other categories or applications, and there's compelling reasons that you have some compelling reasons to convince an officer that you should be granted landing on humanitarian grounds, that's when you would use that application. So the H&C, they're very discretionary, highly discretionary, because they are the exception to the rule. So there's quite a few hurdles that you have to meet and evidence that you have to submit to have a good chance at these cases. And unfortunately, I'm going to kind of sigh here because recently we've been seeing denials coming in, even on spousal H&Cs, and which is unfortunate to see, and even when there's children involved. And that involves a whole other layer. If you get denied on an H&C, you have to then engage the federal court process, and that is not an easy process to engage because you can't just walk into federal court and say, hey, I think the officer was wrong here. You have to seek leave of the court. And what that means is you do written submissions and in paper convince the judge that there's been some error or oversight. And if the judge feels that there is merit in your argument, you would be granted leave to appear in front of federal court, and you would have 45 minutes to make your pitch and a 5-minute rebuttal. I think actually the 45 includes that 5-minute rebuttal. So 40 minutes for your pitch, then the government makes their response, and then you have 5 minutes to give a response. So this H&C process, I'm belaboring this point quite a bit to, I guess, hone in the fact that it is a highly discretionary application. But the FV coding can be applied to these applications to have them priority processed. Next slide. Legalese here, the only points I want you to take away from here is in these humanitarian applications, the onus is on the foreign national, in these cases the victim, to set out humanitarian and compassionate application supporting their request for an exemption. Like I said, it's exception to the rule. So section 25 is the provision in IRPA which allows an officer to consider humanitarian applications and allow for the exception to the rule. So there's some case law that has developed over the years. I'll just get back to questions in a minute. Some case law that has developed over the years regarding, well, what is going to be enough evidence to satisfy humanitarian compassionate evidence. The section 25 refers to unusual and undeserved or disproportionate hardship. Well, what does that mean? So one of the cases that went all the way up to the Supreme Court of Canada is sort of what we as lawyers refer to when we're making submissions. And in that, the court has said decision makers, meaning officers, must have regard to all of the circumstances, including the exceptional nature of H&C relief. And basically, what would decent, fair-minded Canadians have to say? Would they find it simply unacceptable to deny the relief sought? So that's sort of the test that has developed. I'm just going to look at what's going on in the chat. Okay, so there's a question about foreign workers, and I'm going to be dealing with that topic after I finish the H&C. So if we can hold off on that question, please, for now. And I just want to complete the H&C part. Okay, so next slide. So there are a number of factors, we can call them, that officers look at when they're examining humanitarian and compassionate applications, such as how well established are you in Canada? How deep are your roots in Canada? And then what's the hardship of returning back home? But obviously, I mean, establishment in Canada is an important criteria, but in these particular cases, family violence, evidence on family violence, evidence of what's in the best interests of the children, circumstances back home, financial ability are all very important as well. And I'm going to go through each of these briefly. So for the type of evidence that you can put in a humanitarian compassionate application, it's really case dependent. It could be, as the list is here, police report, court documents, letters, support letters, professional reports and letters, photos, emails, and text messages. So it can be an array of different types of evidence. And we often see in these cases, though, we don't have that nice, neat bundle of evidence, which is police reports or criminal records, because many times victims don't report the matter to the police and it doesn't go in the criminal system. So then you're left to gathering evidence and documents by way of an affidavit from the victim, from support workers, transition home workers, victims providers, counselors, professionals. So you build your case that way. Next slide. Sorry, I didn't tell you that this was the slide I was referring to, the different types of evidence that can be submitted. Next slide. And I don't think I really need to go into this too much with the group that's before me. We all know that abuse can take many different forms, from physical, sexual, emotional, psychological, financial, to neglect. And unfortunately, we have victims who have experienced the whole gambit here in terms of the types of abuse. But I've had some that have not had what I call the visible signs of abuse. I had a young lady who it was power and control, financial abuse. Her spouse had taken away her passport. He had, so her ability to leave the country or come and go, denied her communication with her family and relatives abroad. He was controlling her social media. He was doling out money as if she were a child, so giving allowance, but so controlling her financial affairs, controlling her coming and going out of the house. So that was more of this power control, psychological abuse. So we explained all of that through her evidence, which can be put into an affidavit and attached to the application, the humanitarian compassionate application. And I don't think I need to say to individuals here how you have to pace yourself in interviews. I presented on this topic last week to the legal profession and wanted to leave with them the understanding of taking a trauma-informed approach when interviewing victims of violence, that they need to pace themselves. It has to, decision-making in these cases is client-centered. And I can give a couple of examples. I had one lady who came into my office and said, I know you're going to ask me some questions and they're going to take me to a really dark place and I can't do it. And so I'm a female lawyer and thought, it would be easier for her, but she just couldn't go there. So we had to pause the whole process, have her connected with a professional therapist who took the next 2 to 3 months to develop a rapport with her and was able to get the details and put them in a report, which I then used to include with my application. For the most part, that was one of my more extreme examples. If I pace myself with the victim and get information over a series of appointments where they can bring in a support worker with them, or I'm ensuring that they do have some counseling or other support available to them outside of my office, I'm able to manage to get the information that way. But we obviously have to be mindful of triggering the victims that come before us. Next slide. So and this audience will know that when it comes to abusive relationships, children are not immune from the abuse that from being abused themselves or having witnessed the abuse of their parent. So it's important to direct your attention when putting together these files. And I know most of you would probably refer out again to a lawyer or to a legal advocacy center, but as a lawyer, I do rely a lot on you, the people that are on the front line, to help me collect and get information that I'm compiling for these applications. So you're a real source of support for us in doing our job. So when it comes to children, make sure you're getting school records, reports from teachers. I recently had a case where this interim school report showed that the child was being disruptive in class. He was only in grade 2, was snatching things, pushing kids. And when I reviewed this with mom, it was decided that the child needed to see a professional, a child psychiatrist, who connected all the dots and said, the child has witnessed and has been abused, and this behavior is a result of that, and that he needs ongoing support and counseling, and an actual education plan supported by the psychiatrist was put in place. All of that was put in my application. So you have to take the time to, I guess, dig in with your clients and learn about what's happening with the children as well. Next slide. And then what are the circumstances back home? You'll have to ask questions about this. Can they find housing back home? Do they have the resources that they're getting here back in their country? I had a few years back a decision of an officer which actually refused. It was my first ever refusal of a H&C victim of violence application. So I was taken aback. The officer took a very parentalistic approach. This was a victim who was had children in Canada, born in Canada, had a support network here, was actually trying to make it work with her spouse, but there was a court order which protected her and made sure his abuse tended to arise only when he was drinking, so that he was never intoxicated when around the family. But the officer in that decision said, I think it's best that you all go back home away from the abusive partner. And back home, we had already submitted evidence that the parents had their own other teenage child that lived in a small apartment. They could not accommodate mom and 3 children, and that housing for single moms was basically non-existent. So we had included all of that evidence in the application. So it's important to do that. And just to sort of finish the story on that case, I had to seek leave to a federal court on it, got leave, and my argument was that when it came to best interests of the child, the officer didn't apply the law correctly, which is it's not simply it's not a parentalistic approach of saying, well, you all just go and be away from the abuse. Doesn't mean the abuse ends just again because you leave, but you have to look at what is best for the child. Is it best for the child to remain in Canada with the foreign mom in this case? Is it best for the child to leave with the mom, or is it best for the child to remain and the foreign mom to go? So there's sort of 3 scenarios that have to be looked at. And so our argument was this was a very parentalistic decision that ignored that she couldn't go back. There wasn't supports back home. There weren't resources back home, and that she had a solid support network here. So the Department of Justice consented to our appeal, and another officer got the case, and it was decided in her favor. So again, important to explore what's going on back home, and can the victim go back home or not? What are the hurdles? And another layer to that in terms of family support back home is I've had cases where the victim says, even though this abuse wasn't my fault, my leaving this relationship has caused dishonor and shame on my family, and they can't support me. Or I've had the converse where I've had a victim say, my parents are supporting me, but they can't have me return home because my abusive partner has family there that has threatened them there. So really an area that you need to explore with the individual and make sure it's being addressed in the application. Next slide. So this is an important one. So financial ability. When agency applications are submitted, if everything is compelling enough for the officer, you've established and convinced the officer that there's compassionate grounds here, you will get what is called first stage approval. The next part of the process is looking at any medical inadmissibility, criminal inadmissibility, or financial inadmissibility. And pursuant to Section 39, if an individual has gone on social assistance, or it's more than likely they will be relying upon social assistance in the future, that's a grounds for inadmissibility. So in further dialogue with policy people, where it was explained to them that if we again apply the trauma-informed approach to understanding what these victims are going through, and even though we have this expedited TRP that gives an open work permit, not every victim is ready to go and start working right away. They need time to get their footing. They may be dealing with other emergencies, putting out other fires. So they may need to resort to social assistance. And my understanding, and I'd like to hear from people in the group if this is the case or not, because I'm hearing it may have changed, is that in order for victims who've gone into transition homes to transition into second stage housing, they may have to show they're on social assistance. But I'm hearing now that victims are being denied social assistance. So I'm not exactly sure what's going on in that world. But the point I want to leave you with here is, with further advocacy with the policy people, officers have now been given discretion to waive that requirement, meaning that if a victim does have to resort to social assistance, that will not be a ground for inadmissibility. Next slide. Until a decision is made in your agency application, you can continue to send evidence. So if there's updated medical reports, school records, or other relevant information that you think would help an officer understand why there's compelling, compassionate, and humanitarian reasons here to grant this exemption, continue to send it in, because it can be considered up until a decision is made. Again, the onus is on the applicant who is a victim to prove their case, not on the immigration officer to say, hey, can you send me some evidence on this, or what about this? Onus is on you. And like I said, the trend in the decision making is, what I'm seeing is it becoming tougher and tougher, and seeing this catchphrase of insufficient evidence was sent on this, insufficient evidence was sent on this point. So make sure you're continually updating the officer, and all these factors that I've gone through with you, that you send as thorough as evidence as you can. I'm just trying to think of, just country circumstances for victims of violence. It really is the ability to go back if they have children, and to have the resources, in my opinion, if they're getting counseling and supports here, they may not be able to get similar counseling and support there, as well as for housing. Next slide. Okay. I'm just looking at the time. We're at 11:30. We have only until 12. I'm going to quickly run through some of the cases here. So Titova was a case of a woman that had come into Canada, been here for 2 years, a victim of family violence. It was more power and control. It was that, I'm applying for your spouse's sponsorship, I'm withdrawing it. I'm applying, I'm withdrawing it. This was a case I mentioned earlier, which the partner had withdrew just before PR was going to be issued. And the court in that case found that the officer's decision to deny the agency was reasonable, because this victim had only been in Canada for a few years, and most of her family, if not all of her family, were in her home country, which she had spent 30 plus years. So there was reasons in order to succeed in a federal court appeal. Yeah, a federal court will only intervene if you can convince them that the decision of the officer is unreasonable. Just because a court may have made a decision that was otherwise or in favor of the victim doesn't make that decision unreasonable. Sorry, I personally still find that when you have this kind of dynamic where someone is controlling another person's rights and abilities to remain in the country, they have that much power, that's huge abuse. And but when all of the factors were looked at, the factors such as, is she established in Canada, is there hardship to going back home, all of these, and financial ability, all of these were looked at in this case, it was decided that the officer's decision was reasonable. In the AB case, this is a case I mentioned before where there was the applicant had applied for an expedited TRP and an agency. The agency had been refused, but the TRP had been granted. The court in this case, in allowing the appeal and basically saying that I do not agree with the officer's decision, I find it to be unreasonable, found there were some technicalities that the court was able to rely on, such as psychological evidence, which the officer had essentially not interpreted accurately, was a way that allowed the court to find it unreasonable. Also, best interest of the child, that assessment the court felt had not been done as required by the law. But what I liked in this case was overall the court's understanding of these cases involving victims of violence. And the court says the officer did not appear to handle the agency application with the attention and compassion that ought to have been provided to the applicant, a victim of spousal abuse who was deprived of the opportunity to become a permanent resident as a result of the termination of an abusive relationship. So this was this one did have a child, and person was only here for 2 years, but when all the factors were looked at, and there were some, like I said, some factual mistakes made by the officer, which allowed the court to conclude the decision was unreasonable. Next slide. In this case, Jackson, all I want to cite this case for, this was a case with the mom. This was a victim of family violence in Canada, but also a horrific attack in her home country. The officer concluded she could go back home with the children or let the children stay with the abusive partner here in Canada. The officer, the court, in saying the decision was unreasonable, said that the officer didn't consider the evidence of impact on the children of being raised by a mother who faced trauma that led to PTSD in our country. So this is one that speaks to trauma and impact on children. So I'm just going to leave it at that. I just like that decision. I like any decision that really understands the plight of the victims and the trauma that they go through. Next slide. So this is, I think I've talked enough about judicial review, but one other remedy that is available is, if you have a decision that is refused, is to ask the officer to reconsider the decision, but it's in very limited situations that they'll do that. It's either there's been some breach of natural justice, some clerical error, or there's some new evidence available that wasn't available before. And you can have both happening simultaneously, an application in federal court as well as the reconsideration. So that's a lot of information that I've just thrown at you all, and I apologize if it was a bit too much. I'm just going to go into the questions before I get into foreign workers.
There is a question on foreign workers, though. Should I say it to you now, or you want to wait for me until later?
I'm looking at it here.
It's in the chat.
Yeah, who are in unionized workplaces despite being covered by collectives. Some employers telling workers not to contact them. How to reach them? How to reach the union? Gosh, I haven't come up with that scenario. I know of a colleague that works in this area. I mean, I can find out and get the answer back to you, Baljinder.
Sure.
I mean, sorry, I have not had that scenario arise. I mean, I would think there would be some public information about the union, or there usually is a union representative amongst the workers that would have that information, I would think. And so the area that I'm going into next, which is foreign workers, I'm going to preface it by saying this is an area that I'm familiar with, done some work in it, but it's not my deep dive area. My deep dive area is victims of violence. So I'm going to go through the process and procedure and the basics. And I encourage people, and myself, I also send out clients, foreign workers that are in abusive circumstances, to the Migrant Worker Center. And I can, Baljinder, I can provide you their contact information if people want, but they are my go-to people for this area.
Sure, that'll be great, Kamaljit. Then we can share the information with all the group.
Yeah, you know what? Let me just take a moment here. I think their number is 604-669-4482, Migrant Workers Center. Okay, so this is where I would send any complex foreign worker scenario. They used to be called, was it the something to do with the live-in caregivers? They were focused on that, but now they're doing all foreign workers. So we're moving now into foreign workers. And
Kamaljit, there are 4 questions in Q&A.
Okay.
You want me to read those to you, or you want to read it yourself?
Is it on
in the Q&A box?
Is it the section I just did? Let me have a look. Okay. All right, let me see. When you say officer, are you referring to CBSA officer? No, not CBSA officer, immigration officer. CBSA are the officers that are Canada Border Services Agency, and they are dealing with the removals typically and enforcement. So when we're submitting the humanitarian applications and the TRP applications, are going to immigration officers, not the CBSA officers. Okay, the next question is, I have a more general fundamental question. Doesn't the whole idea of a woman's immigration status ever being entirely dependent upon a male's amount to violation of equity under 25 of Charter? Has it ever been argued that placing a woman's status to be so dependent upon a man's, which leads to a man of abuses you've referred to? A good question. I have not heard of it being challenged that way, because obviously these applications are gender neutral applications, and men can also experience violence under that same application. So I have not heard of anyone launching an attack on it under the Charter provisions. And then so once she arrives in Canada, as a matter of the Charter, a woman should automatically have immigration status to eliminate all these abuses. Yeah. I have not launched a Charter challenge. I have not heard of a Charter challenge challenging sort of the sponsorship abuse dynamic. We have a number of policy directives. For example, when we're dealing with sponsorship of a spouse, so let's say the spouse is Canadian and they sponsor someone to Canada, that sponsored spouse is abused. There's already instructions in the immigration application forms to that sponsored victim that they can leave, that even if they have to rely on social assistance, that they can. So immigration has put its mind to that scenario arising, and her status as a PR is not jeopardized because she leaves the abusive relationship. We did have a few years back, I think it was 2012, and Baljinder, you probably remember this, the conditional permanent resident category that was created.
Yes, I remember that, yeah.
To deal with what was like these passport bride and grooms, people just marrying and then taking off, to deal with that fraudulent use of the process. And so then we did a lot of advocacy in that area for arguing that if you're going to have people require people to stay in a genuine relationship for 2 years, you're going to end up with victims staying in abusive relationships. So then they created a exception and a bunch of criteria allowing victims of family violence to be able to exit that relationship without impacting their PR status. I think one of my slides referred to OB 480, that's Operations Bulletin 480, that was created at the time of this conditional permanent residence category. And it's a good resource when you're trying to put together either a TRP application or an agency application based on violence, because it sets out the different types of abuse that a person can experience. So I think, what about medical inadmissibility? Can an officer waive medical inadmissibility? Well, in a humanitarian compassion application, if it's in that context, you can ask on humanitarian grounds that it be waived, that there's humanitarian grounds, and maybe you can explain there's other supports or other ways to deal with the medical inadmissibility. What grounds does the applicant need to provide to withdraw an application? There, again, none really. It can be as simple as I no longer wish to proceed with sponsorship of this spouse, or there's been a breakdown and I'm withdrawing it. Yeah, good question. I wish there was a way. I was just hoping that, you know, the one case I spoke of, that in that case, the court did say, yeah, it was a factor, it was a kind of abuse, but when all the other factors were considered in that H&C, the decision of the officer was found to be reasonable. Okay, so getting to, I didn't think I'd take up all the time, Baljinder.
Oh, no, you have lots of time. Don't worry about it. We have opened the session from 10:30 to 12:30.
Okay.
So you have about 45 minutes.
Okay, all right.
So
I thought I had till 12,
it.
so I was
Yeah.
like, oh my goodness.
Yeah.
Okay, so I'm going to try and wrap up my part by 12. And so I'd like to have a discussion with people and learn from them what's happening out there, because I want to stay informed and take back information to policy people if I can.
Yeah, that will be great, Kamaljit. I also want to know from people, they must be listening to me at this point, what refugee and sponsorship areas of immigration or any kind of vulnerable clients or foreign workers or the work permit areas they want more training on. All these topics are very subdividable. So
Yeah.
if you can ask this question in
Sure.
open for me, that'll be
Yeah,
great.
we'll do that. It's just so, you know, I can't see anyone, so I like to see faces. And so when you're presenting, I can't see anybody. I just see my little box there. But anyways, let's pivot over to foreign workers now. So we know this, that foreign workers, thanks for moving to the next slide, come to Canada. They have hopes of working, and many of them are working towards a path to securing permanent resident status. And we've seen, unfortunately, in this industry, when it comes to foreign workers, and especially in the lower skilled, and I don't like calling it lower skilled, but that's sort of how the rubric is created. I think personally that the workers that have stepped up during the pandemic, frontline workers, whether that's at a grocery store, at a restaurant, at, you know, obviously healthcare in whatever capacity, they allowed us to continuing doing what we were doing, but putting themselves on the line. So I don't see their work as low skilled at all, but much needed. But they are the ones that are taken advantage of a lot and abused, unfortunately. Next slide. So in May 2019, the government made an announcement that they were going to take action to help vulnerable workers. And I just wanted to say that these slides are somehow, the designs happen by themselves in PowerPoint. I'm not this techie. I don't know how this little slide thing happened here. But anyway, so the announcement was made in May, and it was effective June 4th. Migrant workers with employer-specific work permits who are in abusive job situations are able to apply for an open work permit. So so the announcement happened in 2019, the same year that the expedited TRP announcement was made for victims of violence. Next slide. So this is actually taken right from the government website. What kind of things do they see as constituting abuse? So up until the line which is highlighted in yellow, I did this presentation a few years back, and this was a list of different forms of abuse that could take place. Obviously, physical, unsanitary, safe conditions, sexual touching, controlling, stealing, isolating you, taking your money, threats, forcing you to commit fraud. So that was a list. And when I went on in preparation for today, I saw, and I really like that this is there, because this is a scenario that we often get calls about, is a third party charging fees for their job or making promises that are not real. So we have some third party who's helping, quote unquote, with the individual get a work permit. And what that process usually entails is a labor market impact assessment, which are, I'm really sad to say, have been selling in the tens of thousands of dollars. It's become this black market. And they're like, if you pay $30,000, $40,000, $50,000 for this LMIA, you're going to get permanent resident status. And they may be thinking they're getting a job. They're paying this money for this document. They're going to get a job. And then it finds out some of them don't even have a job, or the job's taken away shortly after that. And there's this whole fraudulent scheme they end up being caught up in with. It's just a really, really difficult situation for them, this whole web that they get caught up in. So it's good to see that that is now being viewed as abuse on the worker, because many workers feared coming forward, worrying that they were going to face some sort of criminal repercussion, CBSA enforcement, and that did happen, right? Okay, yeah, I just saw the comment from Laura. Yeah, that's I guess there's a lot of work in that area. Is that, yeah, that's a good question. Why is the passport not in there? That's a form of control. Like I said, I got this from their website. That's definitely a form of abuse and control. Yeah, and that's, in my opinion, that's criminal. And is the ultimate form of abuse. It's just like victims of violence when they take away some of their passports as well, abusive partner. And then what I was interested in seeing, I've got a link here to, there's a link to operations bulletin of the types of abuse. And one of the ones that I saw was reference to forcing workers to work during a pandemic when it was not safe, when their health was not safe. Well, I think I printed it here. Let me just see some of the use that they say around COVID. So if a worker's traveled in from a foreign country, coming to the country, and it was that quarantine period, not allowing them to take that quarantine period, having them work with workers who had symptoms, not letting them take time off when they had symptoms. So that whole COVID understanding is now there in what constitutes abuse. And just before I forget, I want to share one case which took place recently this year. I think it was a foreign worker who applied on H&C grounds, was working maybe in healthcare, and the officer had refused the decision, and it was during the pandemic, and the court said that these workers were hugely instrumental, and the officer failed to understand how important their contribution was during the pandemic. So I really like that case as well. And I like the fact that we're seeing that there is this understanding that you're really putting the health and safety at risk of people if you don't have protocol in place when there's an outbreak or of COVID in your workplace. So moving on, next slide. So things to note about this open work permit. There's no fee for the application, it's fee exempt, but it's a one-time only. So unlike the TRP, which can be renewed for the victims of violence, this is not a TRP, this is an actual work permit. And the reason why it's only one time is that the expectation is that, I'm guessing they're giving them up to at least a year that the individual is allowed to go work for anyone, and that during that 1 year that they'll be able to find some employer who's willing to support them on a work permit. But the reality is, unfortunately, that we have this black market of LMIAs going on. And I know there's been crackdowns, at least in the lower mainland, by CBSA and the RCMP, of employers and representatives who have, sort of colluded to create this LMIA. I mean, the LMIA is endorsed by the province, but before it gets to that, this collusion between an employer and some representative in the community saying that they're going to be able to get this LMIA for them if they pay X amount of dollars. So I don't know how realistic it is for workers in this environment here in 1 year to be able to get an employer to genuinely get them that LMIA. Next slide. Other eligibility criteria: the foreign workers inside Canada, they had to have had a valid employer-specific work permit before applying for the open work permit, and they're being abused or at risk of being abused in relation to a job in Canada. Next slide. This is a process by which to apply for the open work permit. It's done online. And apparently you have to upload all the evidence of abuse in one document in client information. So it's an online process, and there's fields under which you have to click. And again, in preparing for today, I went and found another link. They're recommending that you use this letter of explanation as the tool by which that you upload to claim the open work permit. And then I've provided another link about the process. Again, I defer these cases out to who I see as sort of the specialists in the area, the migrant workers. Next slide is talking about the type of evidence that can be used to prove abuse. And this is taken from the government website as well too. So because we want to know, what do they think that they would accept? So any letters or statements from doctors, professionals, sworn affidavit from the victim themselves, if any report was submitted to CBSA, and if any report was made to employment standards. So if you have an employment standards lawyer involved, they can put that together: emails, text messages, photos, work conditions. So whatever you can think of. I'm just going to go to the chat here. All right, so it looks like this is an excellent resource. I'll be adding it to my list of resources. This is fantastic to know. Thank you, Raul. That's really, really good to know. Thank you. Next slide. So my understanding is that once an application for this foreign worker subject to abuse is for an open work permit is received, that they're supposed to contact the worker in 5 business days, and the worker can be asked to attend an interview. And after an open work permit is granted, immigration may contact the employer to perform an inspection. Okay, next slide. So when, again, in preparing for today, what I found interesting is that there's actually a list of employers that have been identified as being non-compliant and not meeting the responsibilities as an employer under the temporary foreign worker program. So I provided a link, and non-compliance can result in penalties and a ban. And if you go to that link, they actually list the employers, their names, where they are, and what the penalty was. So that's interesting. But I think that's great that is out there now. Next, so if foreign workers have family members here, they may also be eligible for an open work permit, but that application has to be sent at the same time as the foreign workers application. Next slide. So if for some reason they're not eligible, let's say the work permit has already expired, they're not eligible for this very specific open work permit for foreign workers, then they would have to go the route of a temporary work resident permit and apply and request for an open work permit with that, and as well as a humanitarian application to secure their PR status. And so I'm putting my mind back to the fact that these open work permits are given for 1 year, and I'd really like to hear from people out there how realistic for these workers to get those LMA work permits, because if they're not, then after 1 year, they don't have that ability to work anymore. They may have to convert it to a TRP and get open work permit. They may have to just apply for H&C, but I'd like to hear, but let me just finish off. I think I have just a couple of slides left. Next slide. Oh, this was just saying that it's good to see that this process is in place, because we've seen many examples of individuals being abused and controlled in many ways. Next slide. So that's a wrap for me. And sorry, I haven't done, like I said, a deeper dive on the foreign worker area, because it's not the bulk of what I do. And I do refer that out to who I consider to be the go-to people in that industry. Yeah, so I'm going to open it up to questions.
There are a bunch of questions in Q&A, Kamaljit.
Okay. And it looks like Rahul is a great source here, and may turn to Rahul to answer some of them to do with this foreign workers here. Let's have a look. Question and answer. Can videos be an evidence? I would try and submit it. Oh, okay, the question before that, would that also be considered human sex trafficking? So if there's sexual abuse or touching or sexual exploitation, I think human sex trafficking there's some other very specific criteria that the person's been brought into the country and sort of put into that unfortunate type of work. Whereas I think when we're talking about sexual abuse or in the context of a foreign worker being abused, it's scenario limited. Have you as a lawyer been able to get a resolution in writing from any enforcement agencies when a report against the employer? Which type of enforcement agencies? I'm not clear on what that is, but again, the bulk of my work is not when a report is against the employer submitted. If it's submitted to employment standards, again, that work I would defer out to colleagues, and I know colleagues that are employment lawyers that have done reports which to employment standards showing the abuse, and that has resulted in penalties, as well as to if consultants have been involved in sort of this collusion with employers. I've seen complaints go to their review body and investigations being launched there. Service Canada specific, no, I have not dealt with that scenario one. So sorry, I feel like I don't have all the answers for the foreign worker side, but laid out the process there. And Rahul, thank you again for providing so much detail in the chat about what Dignidad provides.
If if that is possible, I can answer some of the questions.
Yes, please.
I will try to help. If you need more deeply answer, please use as the question.
Yes.
Please to Laura, yes, and video can be considered an evidence. The problem that we have for the open work permit to submit the videos or voice records is that you have no way to submit it. So you have to transcribe the videos about those evidence. But you can submit the videos as evidence to another enforcement agencies. You can bring it to the police, you can bring it to the Service Canada, you can bring it to the worker compensation, or you can bring it to the employment standard branch. So with those, in those cases, you can mention that those videos are in those enforcement agencies, and then you put the number of the file that you have been using in the application for open work permit. So that's that could be useful. All the time having videos or having pictures or voice recording or text message are very important as strong evidence. Related to Juan Trevino, Service Canada never will give you the report. They argue that they, under the Act for Privacy Act, they cannot provide to you this information. They only provide to you the information to the employer. The only way that we have been able to get those reports or those statements is when we submit a complaint, for example, for employment standard or for worker compensation or for work compensation or employment standard. Then usually the employer use the statement that Service Canada has been providing to them in order to show as an evidence that they have been in compliance, that they have been respecting the whole rules. And then is the moment when you know that Service Canada already protected the employers, even since they have been doing something wrong. That is the only way that we have to get the statement for some of the agencies. Otherwise, we have been able to get 3 statements for the Service Canada, but through the process of the employment standard and worker compensation. That is the moment when we got the statement. But otherwise, Service Canada usually don't share with you this information. They only mention to you, we are doing the inspection, we are taking seriously the concern or the report, that's it. They don't provide you anything else. The other issue that we wanted to mention related with the open work permit is the open work permit was very strong and very huge fight. Initially, before May 4 or before June 4, it was a open work permit as a pilot project. It was initially as a pilot project. And this pilot project was used, allowed some organization to submit the application for open work permit. But in 2018, we have a strong case about open work permit with several females, farm workers were abused by Golden Eagle. And then we submit a big claim for open work permit, and we did a lot of lobby, almost 1 year of lobby, speaking with everybody in immigration, in Service Canada, with members of the parliament, with everybody. And then in one of the meetings that we have, they say that they will listen to us and they will modify the work permit. And they did those modifications that it wasn't what exactly we were asking for, right? But it was at least a minimum thing. But it is not enough. The open work permit is just a small pill in a big illness in the temporary foreign worker programs.
So Rahul, can I ask you what your experiences are? So when workers are getting this 1 year open work permit and it's coming close to the expiry, what solutions are you finding are available for them?
Well, in the regular procedure, what we do is we take this 1 year open work permit to get another closed work permit. That's the only option that we have been getting, because as it is not renewable, there is no solution already. And it is very complicated to get another job, because usually, even if the employers say that they don't do that, they blacklist the workers. They really blacklist the workers. until you go to apply for another farm, for other construction site, they won't provide you a work because you already were blacklisted. So it became very complicated. That's what we say, that the open work permit is not enough solution, because it just solve a momentum of the abuse and it don't solve the big issue.
That's
What we
what I
have
would,
been,
yeah, that's what I would think, right? In my mind, it's like, what's the next step? Because those LMIAs, employer-specific work permits, are very hard to get.
what we have been saying is that everybody who proved that they are suffering an abuse and has been granted open work permit, the next step should be that the worker should be allowed to get the permanent resident, because they have been proved that they have been good worker, they have no issues, they should be granted about that.
So, but how are you doing that? Through an H&C, or because if they're not in that skilled category? And
No, it is not in the skilled category. We say that we should be considered as the worker as a humanitarian compassion reason.
humanitarian grounds, yes, that's
what we have been insisting in the lobby that we have been doing, right?
Yeah.
So we have been having meeting with Mr. Mendocino, with Mr. Fraser, insisting about this issue, and they promised that in June they will do a review and they will launch some modifications.
So
we don't know.
Pathway, you mean create a pathway for these individuals to PR?
Exactly, but not just for those individuals to PR, but also for the and one sector of the temporary foreign worker who has not been visible. Even that the temporary foreign worker has been invisible, there are other more invisible. Those are the undocumented workers. For example, those who are visitors who come with came to Canada as a tourist visa, but in reality they came to work. They are more invisible and more vulnerable, and there is no path to provide them any service, except for employment standard branch, and except for the worker compensation or human rights. There is no other way that we have to provide attention to those migrant workers, because at the end of the day, they are migrant workers as well. So to answer your question, there is no solution after the open work permit. The only way that we should insist is to get the permanent resident through the humanitarian compassion reasons. That could be the way. I don't know if I answered all the questions. Is there is some remaining?
Thank you so much for helping me here, Rahul. That's very helpful. Like I said,
it's an honor to share what we have been learning through the years. Dignidad has been existing since 2006. During 16 years, we have been doing all this job in volunteer basis. We have no funding, nobody funding us. Wow. Because we have been very critical with the government, and because we are totally biased into the side of the workers. So we don't represent, we don't negotiate with the employer. We are totally biased into the side of the temporary foreign workers.
Right.
So that's what we have been doing. All of us, all our team, we are volunteers. We have another job to pay our bills, and we do the job for free and volunteer.
Thank you so much, Rahul. Thanks for sharing your contact information. I'm gonna throw out a question on the TRP, expedited TRP for victims of family violence. Has anyone had any experience of the type I've talked about, where renewals are not being granted, or any difficulties in the processing time of those TRPs? Okay, and how about on the H&C front for victims of family violence? Any applications that are being returned or refused, or
Kamaljit, I wanted to add a little bit to what Rahul was saying about, that year, that 1 year that you have on the work permit. I know you're moving on to the TRP.
Oh, but that's okay. That's okay. Who's speaking? Because I can't see anyone's face.
Oh, no worries. I'm sorry that you cannot see our face. My name is Juan. I work for Mosaic's Migrant Workers Program. Okay, and we also support workers with open work permits applications.
Sure, yeah. Please go ahead and share.
I share the frustration of many other agencies when it comes to that 1 year. 1 year is definitely not enough for, of course, to find a new employer. It's really, really hard. One thing that we have found useful is to connect with other workers who have been going through similar situations, or to connect with other workers in other farms, right? Because just like Raul said, we don't know what actions the employers are going to take against the worker that left the farm. In previous situations, we have seen that they essentially just talk bad about the worker so that the worker has a hard time finding a new employer, right? Because farmers sometimes they do know each other, but at the same time there are a lot of workers that are working for other farms that might be able to give us an insight of what it's like to work in that workspace, so that we can assess the situation and tell the workers, hey, this is a good place, and we might be able to connect you with them, right? So the temporary foreign worker job bank and just community connections, I think those are the two best leads when it comes to finding a new employer for somebody that it's in that transition period of the 1 year, right? Looking for a new closed work permit. The temporary foreign worker job bank is not the best tool, but it's it's a good starting point. You can also look in the government's website. You can see a list of all employers who have been granted LMIAs in previous years, and that might be another lead. Also, exploring opportunities outside of the province. I think in the most serious cases, when the workers are really eager to stay here, and you're running out of options, it might be a good idea as well, just not to limit your options to the same province. So
more remote areas or outside of the province. Yeah.
Exactly. Yeah. And I think that has been useful for many workers, especially, because other areas that are more rural, like the Okanagan, they might have more work opportunities. So it's good to consider all options when it comes to that.
Yeah, I agree. And I think the continued lobbying by organizations such as yourself to share stories of lived experiences of foreign workers is going to be very impactful if you continue to do that.
Sorry,
sure,
just to add something about what Juan said, some of the cases that we have been doing recently is that the worker get the open work permit, but as they can move to other areas, some of them have been moving to Manitoba, or some of them have been moving to New Brunswick, because they have the rule that after 1 year of working with the place, you can get the permanent residence. So that is some of the action that we have been taking in order to grant the worker they could stay here legally. But even with those options of moving, there is not enough. It has to be something structural, something systemic that has to be changed into the immigration laws. That's what we say, that the Humanitarian Compassion reason should consider those workers who suffer abuse or exploitation in the work site. And
unfortunately, I can tell you, Raul, the agency decisions that we've been seeing coming down the pipe lately have not, the trend has been not favorable, especially for undocumented people. There's sort of this really, officers don't like people being under the radar for many years. And it just doesn't sit well with them. And we're finding that decisions are not, and the agencies are being denied, even though there's other compelling reasons, children that are being impacted and so forth. So agency is, again, supposed to be the exception to the rule, very compelling circumstances, right? And like we've seen abusive applications being returned, for not returned, but I mean denied. So that, like you said, I think, Rahul, something more systemic in terms of a change has to happen. And it can't all be that we all have to rely on this very discretionary agency every time, which is not an easy application to put together. But that's my perspective, I guess, as counsel when I do these. They're tough applications.
That is true, but in some cases, like in Ontario, for example, they allow to get a permanent resident to around 400 undocumented workers in an industry. I don't have the specific data right now, but it is sometimes in many cases, it is a political issue, an economical issue. So some kind of workers are really highly needed, and they are undocumented. They have been providing them the permanent residence.
So I guess
that is the case for the Ontario, for example.
Yeah,
right?
It could be a provincial thing.
Yeah.
Yeah, and it shouldn't be hodgepodge, right? It should be a bit more consistent across the board. But any other questions or comments? We're at 12:15 and happy to answer questions. If not, once again, Rahul, thank you. And Juan, thank you as well. Oh, there's a question. Let me see if I can get to that. I've got a hands up question.
More so a comment, actually.
Okay, sure. Go ahead. Yeah, go ahead.
That from Juan just saying there's not enough support from ESDC to connect employers with workers, even though there's a demand for it, unfortunately.
Yeah, I think that comment was to many people are out of time to apply for the open work permit because unfortunately they don't realize that's an option until after their current permit has expired, and at that point they're no longer eligible. And unfortunately, many of these people get frustrated because you see a long list in the temporary foreign worker job bank of jobs that are available for immigrants and migrant workers. But many employers that are willing and able to hire temporary foreign workers do not have the knowledge. They might not be very familiar with the immigration process. They themselves would have to pay a lot of money to get that as well. So what could happen or ends up happening in those situations is that the employers see fit to charge the worker, right? So you fall again into the same situation when employers don't have the ability to hire workers, so they convince them to pay for the fees themselves. So thousands of dollars, like Kamaljit said, for the LMIA pool, which has to be paid by the employer. And we see a need for ESDC to have a better resource to connect employers and employees, but specifically employees that have been at risk of being in a vulnerable situation or just being abused. Because when we have submitted reports, for instance, to Service Canada, when there's an employer that has it's being abusive, the moment you report that employer, an investigation is started towards that employer. And if that employer has LMIAs in process, those LMIAs are going to be put on hold most likely. So the people depending on those LMIAs to actually get their jobs are going to lose their jobs, right? Because of course, Service Canada or ESDC won't grant that LMIA if they have reports against, if they have reports being made against the employer. So everybody that is dependent on a second LMIA being approved is going to be left without a job, and Service Canada has no resources whatsoever to connect workers and employers. Of course, the work permit is processed by IRCC, but those connections between workers and employees and workers, it's not, there's no measures whatsoever except for the job bank, which is not, unfortunately, a very good resource.
One question that I have for Kamaljit is, we have been dealing all the time with consultants. Those consultants are abusive, and usually they are linked with the employer. So they are connected, are very well coordinated with the employer in order to hide that the employer is charging the worker for the payment for be hired. But that's just one of the things. The biggest thing that we have is that we have some consultant who has been doing a fraud against the hundred of visitors, offering them an open work permit, but at the end they didn't provide the open work permit because it was totally a fraud. So when we reported this issue with the association of the consultant in BC, they say that there is nothing to do. What we should do then is, and I can mention corrupted consultant has been stealing the money to the visitor, promising something that they know that they won't give it to them. And after, when we submit a complaint with the association in order to see if the worker can recover the money or to get some penalties to the consultant or something happened, the association say that they can do nothing. They can do anything.
It's one of those very frustrating areas, Rahul. We see it all the time because lots of money has been paid by the foreign worker, and many times it's cash.
Yes.
No receipt, so there's no proof. And then if you're going to go to the RCMP, it becomes very difficult to establish that that there was fraud or misrepresentation or coercion. They're very difficult cases. And the remedy for the person, again, is that default agency application, but again, it's highly discretionary. And I don't know what to do. We as lawyers struggle because we get clients that come into our office where they've spent more than their life. They've literally, if they have sold lands and properties to pay these exorbitant fees, right? There's just criminal fees. I know that the RCMP and CBSA have been cracking down on employers and sort of these cohorts of consultants that are doing this kind of stuff. So that was was it a year or so ago that I heard in the media about some large crackdown. So I think those cases are working their way through the courts, because there hasn't been a lot of criminal sanctions and penalties, right? Which I think would be more impactful than just a disciplinary body saying, well, this was wrong and you have to give back this money. And they haven't done that even, right? But I think some criminal sanctions may start to send a message to people that this behavior, criminal behavior, will not be tolerated. But they're tough, Rahul. I wish I had an answer. And it's really sad when we do see these clients come into our office with that situation.
So there's a question for you in the Q&A. I wonder if you can type in an answer there while
What is the question? Oh,
and I just see some.
Yes. Dignidad support people outside of Vancouver. We support people across Canada even. We have cases in Nova Scotia. We have cases in Victoria. I am right now just in the Okanagan Valley because we have doing a frontline work here because it's a lot of need here in the Okanagan and there is no many support here. So I am here in the Okanagan, but my team, the other members of the team are also in Victoria, and we are also people in the Fraser Valley. So we are a big group, so we can provide support to people in Victoria, but just workers, because one time for a coincidence, an employer called us because it was a big accident with a worker. So we helped the employer to provide assistance to the worker. But after that, the employer started to sending us a lot of employers to help them, and then say, sorry, we are here to provide support for the workers. So that's the only thing. Everything is related with temporary foreign worker or undocumented people, please refer to us.
Thank you again, Rahul. I think you'll be getting lots of contact. I'm just looking in the chat. There was a question earlier about someone saying they're on a work permit. Can they apply later? Apply for PR. When I apply for PR later, can I apply for my parents together? No, you have to get PR status yourselves first. And then once you're a PR, then you are, they want to see pretty much a 3-year track record of earnings, which have to be above the low income threshold in order to apply for parents. And that whole process is a lottery system, really, because it opens up, I don't even think it opened up this year, but typically beginning of the year, it opens up to show your expression of interest to sponsor your parents, and it's full within a matter of minutes. And then if you make the cut in terms of you made it before the cutoff, you'll get an invitation to apply for your parents. But they have increased the super visa for parents from 2 years to 5 years now, with an ability to renew to an extra 2 years. Now I'm just working down the questions. Someone about how to speak to CBSA. My interaction with CBSA has been, I do duty counsel work for individuals who are detained. So I'll deal with CBSA officers in that context, in the detention hearings and removals, and best ways or tips to communicate with them is, to be, tell your client to be truthful and explain what the situation is and show that you're willing to cooperate and explain the circumstances, the reality of what it is. So being truthful and be willing to cooperate. I mean, I have represented detainees where they're out of their, I guess, immigration options, and it is, they have to make their way back, and we're showing that they're willing to cooperate in that process. And what else? So I'm just going to leave it at if anyone has any anecdotal feedback on TRP's Agency for Victims of Family Violence, I would welcome them. Okay, so now there's questions here. How would you advise workers who are being abused but too scared to report in fear of losing their seasonal work? I mean, that's I don't know if they can do this if they're wanting to get an open work permit. They're going to be having to identify their employer. I don't know, Rahul, if there's other resources for workers while they're thinking about leaving an abusive workplace.
Well, our best experience is that so you have the support of your consulate. That is very weird to have the support. Usually they don't support too much, but then you can ask for a transfer. you can, in order to leave the temporary foreign worker, you can ask for a transfer, especially those who are under the seasonal agriculture worker program. But the other cases, the ag stream or the other kind of job like construction, caregivers, or the other kind of temporary foreign workers, I don't know if they are able to, they are not able to be transferred to another job.
No.
So the only recommendation that we have, don't leave the job and stay in the status that you are legal because your because your work permit is valid, but you cannot work with any other employer. So for us, it's better that you submit the open work permit. At least it is an option for 1 year while you look for another option. So don't lose your status. That is our
Next question, what should workers do if they find their current employer on the list of employers who are found to be non-compliant? That's a good question. I mean, I don't know what the process is there, whether all employees of non-compliant employers are notified and impacted somehow, because yeah, Legal Aid would like to answer. Okay, sorry.
Go ahead, it's yours, Kamaljit. I was just
I was just saying I'm not sure what the process is, but whether immigration or whoever is controlling that list contacts all employees on that list and that their jobs are impacted. I'm not exactly sure how that process would unfold. I just know that there is a list there of employers that are non-compliant. And I think if you're non-compliant, then you're banned for a certain period of time from taking on other foreign workers, but
not necessarily, because there is a kind of steps. So you are found in no compliance, then you can get some penalties, and then you are still there. But you continues being in no compliance, then you will be banned. So, but the problem with the ban is that the employees are very smart, and the company maybe is under the name of the father or the wife or the son. So what they do is just to cancel this company and open a new company under the name of the, I don't know, the grandson or the wife, and then they continue with the abuses under the other name. So that is very often what happened in many cases. I can cite you a bunch of.
Yeah, I'm not sure about the process of notification, because it's saying what should workers do if they find out that their employer is on this list. So like I said, I don't know if all employees are notified. I think if there was a proper LMIA, the person's working properly, I would think they should be fine. And as long as they're not being abused, they should be okay to continue working. But if some kind of ban comes in effect, I think it would be forward moving in terms of being able to hire further foreign workers. But yeah, sorry, there's another question. Do you know of someone without a removal order who has been asked to leave and left voluntarily could have an impact on their record? Usually there's notes that are kept on, on individuals, and you can, these notes can indicate if there's an impact. I mean, if they leave voluntarily, there's no removal order, there's no legal prohibition preventing them from applying to come back into the country, but there may still be some notation in the officer's notes that they were asked to leave and what the circumstances were. I think we're at time now. It's 12:30. Baljinder, I'm going to turn it over to you.
Yeah, Baljinder actually had to step away, Kamaljit. Okay. You can see that she actually snuck off for a meeting. Okay. And maybe, you know what, I will wrap up the session here with everybody who has stuck to the very end. But first, Kamaljit, I just want to say thank you. Thank you for joining us in this space again, offering just your wealth of knowledge when things are constantly changing, and it's a lot of work to keep up with everything. And I really appreciated just how the session turned into a bit of conversation at the end. And Raul, just I learned a lot.
Yeah, no, I really appreciate it. I come to these and learn so much. And so, yeah, Rahul, everyone else who contributed, thank you so much. It makes it a much more engaging process rather than me, like I said, being a talking head. So
yeah. Yeah, so thank you, Kamaljit. If you want, you can step away. You can, yeah, thank you. Thank you for sticking with us for so long. Everybody else, Baljinder had mentioned early earlier, we are interested to know there's so much within this topic. Well, there's so much for us to potentially explore in this topic. So let us know in the evaluation survey or send us an email at outreach at legalaid.bc.ca. The type of sessions we should be holding, what sort of information should we share with everybody? What kind of speakers should we bring in? Let us know. And if there's any other feedback and thoughts too, you can also share that with us. Thank you for joining us. I hope you still have some lunch hour left. And yeah, I guess we'll just sign off here and wish everybody have a good rest of the day. We will be sharing a recording of this presentation along with the materials soon, hopefully by next week, early next week. So yeah, thank you, everybody.
Thank you.
Thank you, Kamaljit.
Thank
Thank you,
you.
everyone.